Welcome back to the Deep Dive. We're continuing our journey through the MPEP, the Manual of Patent Examining Procedure.
Yep.
And today we're digging into Chapter 2100, Patentability.
Specifically, Section 2157.
Right, Section 2157, which is all about improper naming of inventors.
Exactly. And it might sound a bit, administrative.
Like paperwork.
Yeah, like just paperwork.
Yeah.
But getting the inventors named correctly is actually fundamental for a valid patent.
Okay.
Section 2157 really hammers home that, look, even though the old pre-AIA rule, Section 102, about rejecting based on inventorship is gone.
The one tied to the old system.
Right. The basic requirement from 35 U.S.C. Section 115A is still very much alive. You must name the actual inventor or inventors of what you're claiming.
So the law changed, the specific rejection code changed, but the core idea didn't. You still have to get the names right.
Precisely. You have to give credit where it's due, inventively speaking.
And the USPTO, they just assume you've got it right initially.
They do. They operate on a presumption of correctness unless, evidence pops up that suggests otherwise.
Okay, but let's talk about when that assumption is wrong.
Yeah.
Why is it such a big deal? What actually happens if the inventor list isn't spot on?
Well, think about what a patent is. It grants exclusive rights based on an invention.
Okay.
So if you name someone who didn't actually invent, or maybe you leave off someone who did contribute inventively, that creates a fundamental flaw. It can really jeopardize the whole application, potentially invalidating the patent later on.
So listing a non-inventor or omitting a true inventor, those are the main ways to mess this up.
Those are the two big ones, yes. Both can be fatal flaws if not corrected.
So like the manager who maybe, oversaw the project, allocated resources, but didn't actually come up with any of the core ideas, they shouldn't be on there.
Generally, no, unless they contributed to the conception of the claimed invention.
And conversely, every single person who did contribute to that conception needs to be listed.
That's the goal. Inventorship is tied directly to conception, who came up with the idea.
Okay. That seems like it could get complicated in big teams.
It definitely can. But the good news is, if mistakes happen, the MPEP does provide ways to fix them.
Oh, okay, good. So it's not necessarily game over if you realize there's an error.
Yeah.
What are the options? How do you fix it?
Well, there are a few main routes, and it kind of depends on the situation.
Right.
If there's a real dispute, like maybe two different groups claim they invented the same thing first, and it leads back to who derived the invention from whom.
Okay, like a disagreement.
Exactly. For applications subject to it, and typically filed on or after March 16th, 2013, you have derivation proceedings under 35 U.S.C. Section 135. Think of it as a formal process at the USPTO to sort out who the true inventor was when there's a claim of derivation. MPEP 1400 talks about this.
That sounds pretty involved, like for a serious conflict. What about simpler cases? Just an honest mistake?
Yeah, for more straightforward corrections, maybe you misspelled a name, or you forgot to include a joint inventor, or included someone by mistake. There's 37 CFR Section 1.48. That's the main mechanism for requesting an amendment to the named inventorship.
Okay, 1.48, that sounds like the go-to rule for routine fixes.
It often is, but there are some important exceptions. MPE 602.01c points out that 1.48 doesn't apply to reissue applications.
Okay, so reissues are different.
Right. For correcting inventorship and reissues, you need to look at other rules, like 37 CFR 1.171 through 1.175, or MPP section 1412.04, or sometimes you might use a certificate of correction under 37 CFR 1.324 and MPP 4281. And then there are specific rules again for interferences or contested cases before the PTP mentioned in 1.48i.
Wow. Okay, so lots of specific procedures depending on the context. You really need to know where your application stands.
Absolutely.
Let's figure out which rule applies.
What if you just don't fix it? You know there's an error, maybe someone was left off, but you just ignore it. Well, that's risky. If an examiner becomes aware of an inventorship issue, maybe through an information disclosure statement or something else, and you haven't filed a correction request under 1.48, they can actually reject the application. It would be a formal rejection under 35 U.S.C. sections 101 and 115 for failure to properly identify the inventor.
A statutory rejection.
Yes, a statutory rejection. And they often use specific form paragraphs right out of the MPEP to explain the basis for that rejection. So it's definitely not something you want to ignore.
No, definitely not. A full rejection is serious. Can you give us a couple of those sort of practical examples again, like the omitted engineer?
Sure. So Imagine that team of engineers again. One person, let's say, figures out the crucial software algorithm that makes the whole gadget work, but somehow during the filing process, their name gets left off. That's omitting a joint inventor.
Right.
Or the flip side, the project manager, who was great at keeping things on schedule but didn't actually contribute to conceiving any of the claimed features, gets listed. That's erroneously including a non-inventor.
Got it. It boils down to who contributed to the conception of what's actually being claimed.
Exactly that. Conception is key. And in both those scenarios, leaving someone off or adding someone who shouldn't be there, 37 CFR section 1.48 is usually the path to fix it.
And if you don't fix it,
You risk the patent being found invalid later, or at the very least, facing significant delays and procedural hurdles during examination.
okay. Now, you mentioned the AIA earlier, the American Invents Act. How did that specifically impact this inventorship issue?
Yeah, that's a really important clarification in Section 2157. For applications filed under the AIA rules, basically, those filed on or after March 16, 2013, which use the first-inventor-to-file system.
The newer ones.
The newer ones, exactly. You cannot get a rejection under the old pre-AIA Section 102F. That code is specifically linked to the old first-to-invent system and whether the named person was, in fact, the first inventor.
So if an examiner today looking at an AIA application thinks the wrong person is named, they can't use 102F.
Correct. That rejection ground is simply inappropriate for AIA applications. They would need to rely on other provisions, like the Sections 101 and 115 rejection we just talked about, if no correction is made.
Where should examiners or practitioners look for the right guidance then under AIA?
MPP Sections 2159 and Section 2137 provide the relevant context for AIA applications regarding inventorship and derivation. Sections 2131 through 2138 cover the old pre-AIA 102 rules, so you need to be careful which set of guidance applies.
Always important to know which regime your application falls under.
Mm-hmm.
Okay, what about simpler fixes, like just a typo in a name, or maybe the inventors decide they want their names listed in a different order?
Ah, yes. For that, there's 37 CFR 1.48F. That specifically covers correcting or just updating the name itself or changing the order of inventors listed on a non-provisional application.
And how do you do that? Is it complicated?
Not usually. The main things you need are an application data sheet, an ADS, using the format from Section 1.76, showing the correct legal names in the order you want them. And you also have to pay the processing fee that's listed in Section 1.15A.
Seems fairly straightforward for that kind of administrative change. Now, let's talk about the applicant. We keep saying inventor, but who can actually be the applicant on file with the USPTO?
Good question. The term applicant is defined in 37 CFR 1.42, and it's actually broader than just the inventor.
Okay.
So yes, it can be the inventor or all the joint inventors together, but it can also be a legal representative, maybe if the inventor is deceased or incapacitated under 37 CFR 1.43.
Right.
It can even be the other joint inventors acting for someone who is omitted under 37 CFR 1.45.
Interesting.
And very commonly, especially in corporate settings, the applicant can be an assignee, the company or person who has acquired ownership rights to the invention, provided they have a sufficient proprietary interest. That's covered in 37 CFR 1.46.
So the company that employs the inventors often ends up being the applicant.
Very often, yes. If the inventors have assigned their rights, the company can file as the applicant.
And what does that assignee, that company, need to do regarding documentation?
If the assignee is the applicant, it's really important they get the proof of ownership officially recorded with the USPTO.
Like the assignment document.
Exactly. The assignment agreement, or maybe relevant parts of an employment agreement, this has to be recorded under 37 CFR Part 3. And crucially, this needs to be done no later than the date the issue fee for the patent is paid. That's laid out in 37 CFR 1.46b1 and MPP 602.01c. There are specific rules for the cover sheet too in 37 CFR 3.28 and MPP 301V.
Okay, so timely recording is key if the assignee is the applicant. What if it's someone else who claims an ownership interest but isn't a straightforward assignee?
That's less common but possible. If someone believes they have a sufficient proprietary interest but maybe isn't the inventor or a recorded assignee, they can petition to be the applicant under 37 CFR 1.46b2.
A petition.
Yes. They'd need to file a petition, pay the fee under Section 1.119G, provide evidence showing their interest, and include a statement explaining why allowing them to be the applicant is necessary to preserve the rights of all parties involved. MPEP 602.01c touches on this too.
It really sounds like there are layers to this. who invented it, who owns it, who can file it, and how to fix it if the names aren't right initially.
Absolutely. Getting inventorship correct is foundational. And while the system provides ways to correct errors, like we've discussed with 1.48 and other provisions,
Uh-huh.
it's always better to get it right from the very beginning. It just avoids potential headaches, delays, and even challenges to the patent's validity down the road.
So wrapping up our look at MPEP Section 2157, the bottom line is, accurate inventorship isn't just checking a box. It's fundamental to getting a valid patent.
That's the core message.
And while there are procedures, like 37 CFR 1.48, to correct mistakes, you really need to act promptly and use the right procedure for your situation.
Couldn't have said it better. And it really underscores, the practical importance of clear communication and maybe even agreements within research teams about who contributed what right from the start of a project.
That's a great point, and it leads perfectly into a final thought for you, the listener. Considering how much innovation today relies on collaboration, what steps can you or your organization take proactively to make sure you're accurately identifying all the inventors right at the outset? Think about those early conversations.
Definitely something worth considering. Okay, and now we have our standard disclaimers and acknowledgments.
Right. This summary of the APEP was generated using AI tools, including ChatGPT and Notebook LM, and may contain errors or omissions. It is provided for general educational and informational purposes only and is not legal advice or a substitute for formal instruction. For authoritative guidance, please consult the official MPEP, a qualified instructor, or a registered patent practitioner.
And we'd like to extend a special thanks to Mike Shepard, the creative director who organized and guided this entire project. His coordination and leadership were essential in making this comprehensive MPEP audio series possible.